This is the morning brief. We're going to switch gears now, for a moment, and get to talk something else there. It has to do with the controversies, the drama that we've seen in the Senate since early February this year, 2025, between Natasha Akpoti-Uduaghan and the Senate, or perhaps the Senate presidents will take another twist, which took another twist yesterday when the Senate wrote officially saying that, look, you know what, we're not ready for you just yet because the matter is still in court. We'll get some insights and perspective in just a moment. Please stay with us.
Mr. Douglas Ogbankwa, former Publicity Secretary of the NBA Benin Branch, joins us now to make sense of what is playing out as far as the Natasha Akpoti-Uduaghan, suspended senator, and the Senate, or maybe the Senate president this time, is concerned. Mr. Ogbankwa, thank you so much for coming on the program.
It's a pleasure to be here.
So I don't know how we got here. Okay, maybe I know how we got here, but it's becoming a bit... Something that is simple is becoming convoluted. So there are three parts to this. So the benefit of Nigerians, so that you help us make sense of the situation. So there are three things that had to do with Natasha Akpoti, the senator, and the Senate. One started with what they call parliamentary misconduct, outbursts, and what they consider disrespect to the office of the Senate president that earned the suspension. And then things quickly snowballed into the issue of allegations of sexual assaults against the Senate president. That got a lot of conversation. Whilst that was going on, we now got another dimension to it that had to do with allegations of attempted assassination against her. And then this, she was sued, the federal government being the principal complainant, the nominal complainant being the Senate president and former governor of Kogi State, Yaya Bello. That's how we got here. Now, judicial intervention came in, and we saw that enrolled order at the beginning. And there were multiple interpretations to whether or not the court said she can resume or she cannot resume. The lawyers were divided on, in fact, the language sounded like it was more of an obiter dictum in an enrolled order. But that's what we found ourselves. But the Senate has now said that case is still in court. For that, you can't resume. People are faulting the Senate. How do you interpret this?
Thank you very much. First of all, it is important for us to follow the sequence of events, how we got here. You have given a succinct analysis of what happened. Just to add that it's important for us to know that both parties have been in adherence with the law one way or the other, and I would analyze that in a bit. First of all, why Senator Natasha Akpoti was still in court, the Senate proceeded to pronounce the suspension on her. As far as I'm concerned, that is double standard, because if they are saying the case is still in court and they cannot proceed with the matter, then why did you pronounce the suspension on her while the case is still in court? Now, having also said that, I would say that the conduct of Senator Natasha Akpoti on the floor of the House was unbecoming of that of a senator. Now, you must understand this, that the Constitution have given the Senate the powers to regulate its affairs, its procedure, and the way sittings we hold. Now, the Senate, in its wisdom, has promulgated rules that would regulate how they conduct their affairs. And according to the Senate rules, the Senate president is the only person that has exclusive powers to determine sitting position. And according to the same Senate rules, it is when you are seated in the position allocated to you by the Senate president that you can be heard. You cannot be bigger than a system. Senator Natasha Akpoti made a very vital slip, he should have first of all gone to the seat allocated to her by the Senate President, and from that seat address the Senate President. In any case, the language of the parliament, there's a law, they say you must use a parliamentary language once addressing the leader of the House. Having also said that, I also want to say that the Senate as an institution has no power to suspend Senator Natasha Akpoti for 6 months. This is because a senator of the Federal Republic of Nigeria is not an employee of the Senate. Such a senator is a representative of his or her people. He was elected by his or her people. The Constitution of the Federal Republic of Nigeria, 1999, as amended, is clear and ambiguous to the fact that there shall be a senator for each of the 109 Senate each of the 109 senatorial districts, of the Federal Republic of Nigeria. And in the case of the Kaduna State House of Assembly case, which was decided by the Court of Appeal, the Court of Appeal, it was an affirmative decision, unlike in Senator Natasha Akpoti's case, which, in my opinion, the judgment left a lot to be desired. In that case, it was so clearly stated that a member of a legislative house is not an employee of the legislative house, that the relationship between a member of the legislative house and the legislative house is not a master relationship. A Senate President, a Speaker, is a interparent. Equals. Person is only privileged to be chosen among his or her mates to be so elected. But once such a person has been elected, you that elected him or her must accord such a person the respect and the authority as provided by the Constitution and the rules. Now, let's come to something very interesting that Nigerians are missing. And that's why I see this case is very complicated. And Senator Natasha Akpoti should be very careful, else it's going to get more complicated. And I'll tell you why. Why the case was still in court. Senator Natasha Akpoti issued a Facebook post which she called, unquote, an apology. In that quote, she satirically ridiculed the person and office of the Senate President, the Senate President as an institution. It was based on that Honorable Justice Binta Iyaku gave the order saying that Senator Natasha Akpoti is guilty of contempt. And let me tell you something, that is a criminal conviction. Contempt is a quasi-criminal matter. And said she should pay 5 million naira to the federal government coffers. And I need to say this. She, in her wisdom, now appealed to the Court of Appeal. Now, why the whole shenanigans was ongoing, you realize that Senator Akpoti landed in her constituency with a helicopter. In that particular rally, she made very, very strong allegation against the Senate President and the former governor of Kogi State, now Senator Yaya Bello. And I quote, according to even the charge filed by the Office of the Attorney General, that Senator Akpoti said that in a meeting between the Senate President and Senator Yaya Bello, she stated that it was part of the meeting, the discussion that Akpabio had with Yaya Bello that night to eliminate me. Yes. That is a very, very wieldy allegation.
Mr. Ogbankwa,
these persons, that's the Senate President and Senator Akpabio, did a petition to the Appellate Authority. They invited Senator Natasha Akpoti to substantiate
Mr.
claim.
Yes, Mr. Ogbankwa.
Based on that, She was charged to court for cyberbullying, and according to the cyber crime prohibition act 2015 as amended.
Yes. So, I mean, it's interesting walking us through that historical background and all of that. Let me see how I can keep my questions really very short, because I have a number of them to ask. So, as a legal practitioner, as a lawyer, based on the facts that you have, I wonder which side you think appears to have the stronger legal position.
The matter is sub judice, and I only just read out the facts for us all to be able to make our own opinion. Now, I need to tell Nigerians this, that I need to say this: what you hear and see in social media is different.
All right, Mr. Ogbankwa, I don't know network issues, but let's bring in
in real life. So I need to say this, that many Nigerians are carried away by the trappings of the euphoria of social media. You need to situate these issues according to what you are seeing in the case file.
All right, Mr. Ogbankwa, if I may butt in, my apologies, Mr. Ogbankwa, if I may butt in just a moment. My apologies if I may butt in. If you can hear us so that we can have a free-flow conversation because of the time we have. Let's bring in Mr. Mark Jacobs. He's a former legal advisor of the People's Democratic Party. He joins us virtually from the nation's capital. Mr. Jacobs, thank you so much for coming on the program.
Thank you so much. It's good to join you.
A quick one. What's your interpretation of what's really playing out? Some people are saying this conundrum even started from that enrolled order where it looks like the judge was actually giving an opinion or an obiter dictum rather than an enforceable order of courts in terms of whether or not she should resume, because he used language like in his own, in the opinion of the honorable judge, the 6 months is excessive. But now we're here, she has written to say, my 6 months is done and dusted. I want to resume, and they say no. It's still a subject under adjudication. How do you interpret this? One as a lawyer, two as a member of the People's Democratic Party?
Well, what I see is a further display of impunity gone too wild. Because if anybody cares to listen to the National Assembly, particularly the current Senate, they have always insisted that the courts or nobody at all should interfere with their exercise of judicial, constitutional powers to discipline their members. And they have always said that it is a constitutional donation that should not be taken away by the courts or by anybody. So, and looking at the history of that matter, when the matter went to court, the defense, if anybody has bothered to look at the processes, what the National Assembly was saying is that they exercise their powers under the Constitution and under their rules, and that the courts should not even interfere. What that certainly means is that they claim and they want to rely on the independence of the legislature, which is a respected norm in federalism. But you see, you can't blow hot and cold at the same time. You cannot be saying that courts should not interfere with the use or with the exercise of your powers and the implementation of your rules, and then turn around to say that because a matter is in court, you are not also going to comply with your own rules. The National Assembly or the Senate suspended this woman for 6 months. There should be no discussion as to when 6 months expire. There should not be any disguise. There is no confusion here. So when 6 months expire, naturally, under their rules, without the help of any court, without the interference of any court, this woman should be allowed to resume her seat. But you see, it is a situation we have today where people choose and pick what to obey and who to respond to.
All right.
They understand very well that the whole world is looking at them. They know very well that they don't have any justification to prevent this lady from resuming her seat. But because they want to hide and seek, they will continue to say that there's a court process. The court order or the court judgment by Justice Nyako is very clear. If a court says that what you did is unconstitutional or is excessive and is not correct, it goes to the bottom, to the root of the exercise of your powers. And it literally says what you did was wrong. And you should not be picking and choosing what to do with that interpretation. So it's a pity that they have people advising them to be disobedient, to be disrespectful to the courts. Once a court says, even in passing, that what you have done is wrong, what does it mean?
Mr. Douglas.
If it says
Mr. Douglas,
the exercise of your power was excessive
yes,
and wrong, you don't need anybody to come and tell you that what you did was wrong and you should reverse it. But you see, when the judgment came, they were saying, first of all, that they have not seen the certified true copy. Then two, they quickly went on appeal. And are now, they are now using the appeal as a basis to disobey their own rules.
So I wonder...
This is contradiction. This is...
Yes, so that we can get in one or two more questions since you've only just joined us. So my first question is, I remember that the Senator Natasha herself had mentioned that she has very strong evidence against the Senate President over, allegedly sexual harassment. The arguments for from the camp of the Senate President is that we've not seen those evidence just yet. Bring it out. I remember the lawyers of Akpabio saying, Mondo Bani, one of them saying, look, bring the evidence you say you have. So that's my first question to you. Why is the evidence that she has not out yet in the public domain since she's allegedly, been crying out loud that she's facing some sort of humiliation or some sort of victimization? That's one. Two, the Senate President shares a very special relationship with the 001 of this country, Mr. President. Do you think it has gotten to the point where Mr. President should intervene?
First of all, let's distinguish between the Senate obeying their own rules. If you suspend your member for 6 months, at the expiration of 6 months, there should be no discussion, there should be no hesitation in allowing the person to resume her seat. That should be very clear. It's part of their rules. You make a rule, you make a decision, and you give it a timeline. The decision has a lifespan. That lifespan expires without discussion, without argument. Let's distinguish that from the issues of the allegations. Now, on the allegations, if I say I have an evidence against you, will I be wise to bring it to you? You who is supposed to be the defendant, I should bring the evidence and give you. For what? The court, the matter is in court. That is what people should be waiting for. They should say, let the matter proceed in court so that we see the evidence. But they are the ones that have been fighting against the progression of the matter, filing one objection or the other, making sure that we don't get to the stage of hearing the matter properly. Let them allow the court process the proceedings to continue. We are still at very preliminary stages. They have refused to allow the matter to proceed. And every day, they are spinning one act or the other to make sure that we don't get to the stage of hearing. Right. I don't know what evidence she has, and I don't even really care. But the point is, you made a decision, and you gave a timeline to your decision. You gave it lifespan, 6 months.
All right.
That 6 months or those 6 months have expired. You don't need to be hiding behind anything to obey your own ruls. When you make a rule, stick to it.
All right.
6 months should be 6 months. That's
yes.
the circumstance. You can't be hiding, doing here.
Yeah, so let's bring in Mr. Ogbankwa into the conversation as well. Mr. Ogbankwa, in the aftermath of all of what has played out, the drama, the saga, I would like you to perhaps paint a picture of what the wider implications are for us, as a people, as a nation.
Very well, I'll do that, but I think I owe it as a duty to situate some of the issues that the National Legal Advisor has stated, of the PDP has stated. And first of all, I feel that, I know that there are several cases in court, and there are a lot of them that Senator Natasha has filed processes but we don't know of anyone where she has indicated any evidence against Senator, distinguished Senator Akpoti, the Senate President. Now, it's very important that the one that the National Legal Advisor is talking about, filing processes, is there are cases that, that have been filed here and there, several cases. One of them has been determined by Honorable Justice Binta Nyako in her wisdom. Now, I also want to state that Senator Akpabio's wife also sued Natasha Akpoti for defamation. I don't know if Senator Natasha have filed a defense, and I can't comment on that, whether or not she put any evidence. But the Nigeria that I know, let's be very, very frank, when a senator was alleged to have collected some dollars, we heard the voice note even before the matter went to court. That is the truth. And so the kind of I'm a trial lawyer, and I know exactly what I'm saying, and I'm somebody that understands how, unquote, the women folks tend to use sexuality as a weapon. The weaponize sexuality sometimes.
Mr. Ogbankwa, if you can hear me for just a moment. Mr. Ogbankwa, can you hear me, sir? Okay, because of time. So let's just hit this as quickly as possible, because I think what Nigerians are more interested in right now, which I want both of you who are lawyers to speak to, and this question is for both of you gentlemen. Mr. Ogbankwa, is the Senate right or wrong in stopping her from resuming because the case is on appeal? That's a straight question, if you can answer that.
Are you asking me that question?
Yes, Mr. Ogbankwa.
There's nothing stopping her. I'm someone that I treat issues dispassionately. The Senate rules are clear. If the Senate says in one breath that no court of law can stop them from suspending Senator Natasha Akpoti, the Senate cannot now, you cannot pick and choose. You cannot appropriate and reprobate. Now come and say in another breath that because the case is in court, she cannot come back. I think whoever gave that advice misadvised the Senate. And I think they should allow her to resume. If not for anything, Senator Natasha Akpoti needs to represent her constituents. Okay. There are people who are in that constituency that have not been represented for 6 months, which in my view is even illegal. In Senator Belaye's case, decided by Bello J of the FCT High Court, stated that you can only suspend according to your rules. And the rules of the House of Representatives then actually indicated that you can only suspend for 14 days.
All right, Mr. Ogbankwa.
Does not give you power to suspend for 6 months.
Yeah, all right, so, yes, because this is one of the very first time we're seeing this long, because I know that Omar Agege fought it as well. You remember that incident before he became DSP. Mr. Mark, let's find out what options are left for her, because I know she fought the battle to become a senator. She is the court. She came through. So all of that time was lost. And now adding another 6 months is another kettle of fish. And then there was even an attempt to even recall her. What options are left her right now in the law?
Let me start by saying, look, I have had the privilege of seeing some of the processes and interrogating the case. The truth remains that when impunity gets to where the courts are being ridiculed by politicians, then we're in trouble. And nobody should support such behavior. The National Assembly cannot and should not be allowed to do as it wishes. The Senate should not be allowed to behave as though nobody, not the judiciary, not the executive, can touch them. And that is what is happening. Impunity is being raised to the high heavens. And it is wrong for anybody to say they have a choice or they are right. The National Assembly should be seen to be a beacon of hope and a protector of the laws that they make. They are the parliament in Nigeria, and they are the owners or the makers of the laws. So when you make a law and you turn around and you are toying with it, the supremacy of the judiciary when it comes to decisions like this must not be toyed with. You made a decision suspending somebody, the person went to court, you have resisted and you have said, you have brought up everything to justify your actions. A court has said that what you did was excessive and wrong. There should be no discussion or hesitation in recalling her, even before today. But today, the 6 months that you prescribed, you know that those 6 months have expired. There should be no discussion and no hesitation in allowing the person to resume his seat. And it's a shame that we get to where the National Assembly, the owners and the makers of our laws, will be picking and choosing what to do when it comes to law.
Mr. Jacobs.
What China's is doing is correct, is in the right way. Let these matters be expatiated and exposed. Let the National Assembly come up with a defense. Why they will not obey their own timelines?
All right.
When they make timelines, they must obey the timelines.
All right, Mr. Jacobs.
Without waiting for any court.
Yes, it's interesting. You know, within our climb and our jurisprudence, it looks like there's a culture of cherry picking on what is convenient. And so that's why I'm sure you're raising this concern as far as this is concerned. But we hope for a resolution somehow, because so many lost days for her as far as this issue is concerned. Mark Jacobs is a former legal advisor of the People's Democratic Party, joining us virtually. Also, Douglas Ogbankwa, former Publicity Secretary of the NBA Benin Branch. Gentlemen, we thank you for your expertise that you brought to this conversation. Thank you, sirs.